If you were just in a serious car accident in California, stop what you're doing and watch every second of this video, because I'm going to show you exactly what the insurance company does not want you to know. And I'm going to show you the specific moves that will either make or destroy your case. This isn't generic legal advice you'll get from a Google search. This is the inside playbook. The stuff my clients wish they knew on day one. You see, most injured people leave 70, 80, sometimes even 90% of what they're owed sitting on the table. And it's not because they had a bad case, it's because they made avoidable mistakes in the first 72 hours. I'm going to make sure that you don't do that. Stay with me. Quick background just so you know why you should listen to me. I'm Steve Sweat. I'm a personal injury attorney based here in Los Angeles, and I've spent the last 30 years in the trenches going up against some of the biggest insurance companies in the country. Allstate, State Farm, Farmers, you name them. I've seen what happens when people handle this right, and I've seen what happens when they don't. This channel exists for one reason: to give you, the injured person, the same information my paying clients get for free. So let's get into it. Here's a fact nobody tells you. The insurance company assigned to your claim started building a case against you the moment that the accident was reported. Their job is to pay you as little as possible, full stop. So what you do in the first 72 hours determines whether you're walking into that negotiation with leverage or walking out empty-handed. Mistake number one, giving a recorded statement. The adjuster will call you probably within 24 hours. They'll sound friendly. They'll say it's just routine. They'll ask you to give a recorded statement. Do not do it. You are not legally required to give one to the other driver's insurance company. And anything you say, anything, can be used to minimize your claim. You're injured, you're in shock, you don't know the full extent of your injuries yet. This is not the time to go on record. Politely tell them your attorney will be in touch, then call an attorney. Mistake number two, delaying medical treatment. I cannot stress this enough. See a doctor immediately. Same day if possible, 2 days max. Here's why. Insurance companies use something called a gap in treatment argument. If you wait 5 days, 10 days to see a doctor, they will argue your injuries weren't that serious. They will argue you must have been hurt doing something else. The medical record is your evidence. The sooner you create it, the stronger your case. Mistake number three, posting on social media. Put your phone down. Get off Instagram. Don't post anything. Not the accident scene, not a photo of you at dinner 2 weeks later saying you're finally feeling better. Nothing. Insurance defense teams absolutely do monitor social media. I've seen cases gutted by a single photo. Dark mode on your profile starting now. Mistake number four, accepting an early settlement offer. They may come to you fast with a check, $2,500, $5,000 maybe, even $15,000. Who knows? It feels like a lot when you're stressed and your bills are piling up. That offer is not generosity. It's a fire sale. They want to close your case before you know how badly you're injured or what your case is actually worth. Once you accept and sign that release, it's over. You cannot go back, even if you need surgery 6 months later. Do not touch that money until you've talked to an attorney. Most people have no idea how personal injury cases actually work in California, so let me break it down for you in plain English. Your case has two categories of damages. Economic damages, these are the hard numbers: medical bills, past and future lost wages, time you missed from work, future lost earning capacity if your injury affects your ability to work long term, property damage, your vehicle, your personal property, future medical care, surgeries, physical therapy, medications you'll need going forward. And then you have non-economic damages. The bigger number. This is where most of the value in serious injury cases lives. And it's where insurance companies fight the hardest. Pain and suffering, emotional distress, loss of enjoyment of life, loss of consortium, in other words, the impact on your marriage or family relationships, disfigurement or permanent disability. In a serious case, non-economic damages can be multiples of your medical bills. I've seen clients with $80,000 in medical bills receive seven-figure settlements because of the impact on their daily life. But here's the thing. None of this happens automatically. You have to build the case. You have to document it. You have to prove it. That's what a good attorney does. So let's talk about what insurance companies use against you. They will argue you had a pre-existing condition. You didn't seek treatment fast enough. You didn't follow your doctor's orders. Your injuries are, quote, soft tissue and not serious. The accident was partially your fault. California is a comparative fault state, meaning your damages can be reduced by your percentage of fault. Every single one of these is a line of attack, and every single one of them can be defended if you have the right documentation and the right attorney. I want to pull back the curtain on something most people never see. When you file an injury claim, the insurance company opens a reserves file. That's an internal estimate of what they expect to pay on your claim. And here's the dirty secret. Their adjusters are trained and incentivized to keep that number very low. They have manuals, literal manuals, with scripts designed to get injured people to undervalue their claims. They are not your friend. They don't care about your recovery. They care about their loss ratios. So let's talk about the lowball playbook. Here's what they typically do. Call you early before you know your diagnosis, offer a small amount to, quote, help with the bills, then have you sign a release, drag out the process, hoping you'll get desperate and settle cheap, dispute liability even when their driver was clearly at fault, send you to their preferred doctors who consistently find minimal injuries, use delay tactics to force a statute of limitations problem. In California, you generally have 2 years to file a lawsuit. I see this every week. And when a client comes to me after they've already made some of these mistakes, our options are more limited. That's why you're watching this video, so you don't become that person. Okay, let's say you've done everything right. You've gotten medical care, you've documented everything, you're ready to talk to a lawyer. Here's what to look for and what to avoid. Let's talk about green flags. 1, they actually practice personal injury law, not a general practice firm that does a little of everything. They have trial experience. An attorney who never goes to trial, the insurance company knows it. They lowball those attorneys every time. You speak to an actual attorney, not a case manager or intake staff. They explain their fee structure clearly. Most personal injury attorneys work on a contingency. They don't get paid unless you do. They give you honest expectations, not just the number you want to hear. So let's talk about red flags. Billboard attorneys with 800 case managers and you never talk to a lawyer. Pressure to settle fast, vague answers about case value before they've reviewed your medical records. No straight answers about who's actually working your file. The single most important question you can ask: will I be able to speak directly with the attorney handling my case? If the answer is no, walk out. You deserve to know who's fighting for you. California has some specific laws that directly affect your injury case. Here are the ones that matter the most. Number 1, the statute of limitations. In most car accident cases in California, you have only 2 years from the date of the accident to file a lawsuit. If you miss that deadline, your case is gone forever. No exceptions. If a government vehicle was involved, a city bus, a county truck, a state vehicle, you may have as little as 6 months to file a government tort claim. This is critical. Comparative fault. California follows pure comparative fault. That means even if you were 30% responsible for an accident, you can still recover 70% of your damages. Don't let an insurance adjuster use partial fault as a reason to deny your whole claim. Uninsured/underinsured motorist coverage. If the driver who hit you has no insurance or not enough insurance, your own UM/UIM coverage may be available to you. A lot of people don't realize this is an option. Always look at your own policy. Lien rights. If you have health insurance, Medi-Cal or Medicare, they may have a right to be reimbursed from your settlement. This doesn't eliminate your recovery, but it needs to be managed carefully. An experienced attorney handles this negotiation as part of maximizing your takeaway home, what you take home. I hear this all the time. Let me address the 3 biggest objections I get. Number 1, the accident wasn't that bad. The severity of the impact and the severity of your injury are not the same thing. Low-speed crashes routinely cause herniated discs, concussions, and soft tissue injuries that last for years. The car can look fine and you can still be seriously hurt. Don't make that determination yourself. Let a doctor and an attorney make it. I can't afford a lawyer. Personal injury lawyers work on a contingency. You pay nothing up front, nothing out of pocket ever. If we don't win, you don't owe attorney's fees. The fee comes from the settlement or verdict. So cost is not a barrier, not even a little bit. I don't want to be in a lawsuit. Most cases settle without ever filing a lawsuit, let alone going to trial. But having an attorney who is willing to and able to take your case to trial, that's what puts maximum pressure on the insurance company to settle fairly. It's the credible thread that changes everything. Look, if you're watching this video, there's a good chance you or someone you love was just seriously hurt. And I want you to know something. You don't have to figure this out alone. I built this practice because I believe that injured people deserve to know what they're entitled to, and they deserve to actually get it. Here's what I'm offering to you right now. Call us at 866-966-5240. When you call that number, you will speak with me, an actual attorney, not an intake coordinator, not a call center, not someone reading from a script, an attorney. We will talk about your accident. I will tell you honestly whether I think you have a case, what it might be worth, and exactly what I would do to fight for you. That call costs you nothing. It takes 15 minutes, and it could be the most important call you make this year. 866-966-5240. Call now, don't wait. The clock on your case is already running. If you're not ready to call yet, do this right now. Hit subscribe. I put out videos every week on California injury law, insurance tactics, and how to protect yourself. Drop a comment below with your question. I read every single one. Share this with someone who's recently in an accident. It could genuinely change their outcome. I'll see you on the next one.